Hello and welcome to the Danesh Show. I am Noah Danesh. Today we have a very special guest, Judge Treu. Thank you so much for joining me, Judge Treu.
My pleasure, Noah.
Thank you. Judge Treu is one of the Los Angeles Superior Court judges. So Judge Treu, can you first begin by telling us how you got into the field of law?
Well, it was a long route, Noah. My family in multiple generations has suffered as a result of communism, fascism, and I've lost family members over the last century because of these two extremist positions, neither of which ever respected the rule of law. And so when I became a United States citizen, I decided to go to college here, study pre-law, law, and get into a field where I could help people make sure that they were respected by and cared by the law.
Prior to becoming the judge, what was your experience in law?
I was a lawyer for 20 years before becoming a judge. I first started out in an insurance defense firm doing civil litigation. Then I went out on my own, did criminal work and civil litigation until 1995, when I was appointed by Governor Pete Wilson to the Citrus Municipal Court in West Covina.
And for viewers that don't know, can you kind of explain how the Superior Court system works?
We are now a unified court system in Los Angeles County. We used to have a municipal court, or various municipal courts. In 2000, these were all unified into the Superior Court. So you'll never have experience before a municipal court again in Los Angeles or LA County, or for that matter for the whole state. The whole state has gone to the Superior Court system. Superior Court is responsible for the trial level of all actions, whether criminal, civil, family law, probate, juvenile delinquency, juvenile dependency, and that is where the people come, and you normally see on television people testifying or see court proceedings. The next level up is the Court of Appeal, which does not take testimony, but which relies on the record made in the Superior Court and on the legal arguments then based upon claimed error in those Superior Court actions. Then the next level up, of course, is the Supreme Court of California, which does not have to take automatically, except for death penalty cases, does not have to take automatically any appeals from the Court of Appeal, but picks and chooses the cases it wishes to take based upon importance and maybe differences of opinion between two various courts of appeal.
Yes. And what's your duty as a judge in this system?
My duty as a judge is to make sure that justice is applied fairly and that it is perceived to be applied fairly. Because even though a judge sitting on a bench may think that he or she is doing the right thing, if the people in front of him or her aren't perceiving in their own mind that he or she is thinking about all their positions or arguments, or perhaps articulating something that comes out in a way that they may conceive to be unfriendly, even though it's correct legally, the judge isn't projecting what we want to project, and that is to make sure that the people before us and the public in general perceive us as listening to all sides, making a fair decision, and making it politely.
And what do you see as the most difficult part of your position as judge?
The most difficult part is, well, I do family law right now. So it's very difficult in situations where parents are unable or unwilling to talk to each other and to communicate for the best interests of the children. There are just too many circumstances where parents cannot see beyond their individual differences with each other, their history of antagonism, and see that that manifestation of unfriendliness is very harmful for the children involved. And so it's very difficult to see that, and then I try to break that cycle if I can.
Yes. And on the opposing side, what do you think is probably the most rewarding aspect of your job?
The most rewarding is when in family law, for example, when I see two parties, rarely it happens, but it will happen from time to time, say, you know, we think this divorce was a mistake, so we're going to get back together again and work it out from there with our kids. That's the most rewarding part. But even in the absence of such agreement, when you see that you've made a decision that has benefited a child, even though the parents may not necessarily agree at the moment, it is very, very rewarding. I had, for example, many years ago, a family law lawyer come to see me and tell me the results of a story of a case that I had handled years before, and I had awarded custody to a child in a particular way that one parent didn't like. But that child then, who was a teenager, the lawyer told me, blossomed and turned into a writer and wrote a screenplay. And it was just a very wonderful feeling that I had. Unfortunately, we don't have the time or the ability to follow up on all of our cases, and so we don't know what happens in most cases.
And a major decision you were also recently a part of involved teachers and tenure. Can you elaborate on that case a little bit, please?
Well, that case is now final, so I can talk about it. Otherwise, I couldn't talk about it. But it did involve a constitutional challenge to various statutes in California under the Education Code, dealing with whether or not teachers were tenured too quickly, whether it was too difficult to terminate teachers who weren't performing properly, and whether or not it was constitutional to have a teacher who was hired last, fired first in times of an economic downturn, irrespective of how qualified that teacher was, as opposed to a more experienced teacher who perhaps shouldn't be in the profession. So there were various constitutional issues raised. We had about a 3-month trial, and I found in favor of the plaintiffs, finding that these laws were unconstitutional, but I stayed, that is, postponed the effect of my decision until an appeals court could take a look at it.
Mm-hmm. And so for the advocates who are saying that no, the teachers should be tenured and it should be difficult to fire, what was your perspective on that?
Well, I think there was a misperception in the general public of the effect of my decision. I never indicated that teachers should not be tenured. I was very clear in the opinion, if it was read carefully by everyone, that I said that the issue of tenure is not before the court, but is the issue of rights that are beyond those rights, perhaps, that other a union or collective bargaining parties may have. For example, the non-certified members of the community, i.e. Cooks, janitors, other employees of the school, have as much right to collective bargaining rights as the teachers do. But the question was whether or not there was more rights in effect for teachers as opposed to anyone else. Mm-hmm. And there's a legitimate debate on that issue. But in this particular case, given the evidence, I found that the statutes as they were written were unconstitutional.
And when you're looking at a case, what is your thought process of looking at the evidence? How do you get to your point of making your decision?
Well, you have to look at the evidence, obviously, determine the believability of the witnesses before you, rely on cross-examination, because that's where the truth often is revealed by vigorous cross-examination of a witness, compare their testimony with documentary evidence that may be before you, and then use your experience as a judicial officer to determine the believability and to determine the result after careful thought. This matter was taken under submission and for several weeks and before I wrote the decision.
Yes. And then so you also said you kept a stay until it goes to the appeals court. Mm-hmm. So does that mean that that there's going to be further discussion about it, or?
Well, it's gone to the appeals court, and
yes.
The appeals court reversed my decision based upon factors that they felt were relevant. And so the ban on those statutes never went into effect because I had stayed them pending the appeals court. The Supreme Court was then asked to hear the case, and the Supreme Court declined. As I indicated earlier, they can decline to hear a case. It takes a 4-3 vote of the 7 justices to decide to hear a case. 3 justices wanted to hear this case. 4 did not. And of those 3, 2, Justices Cuellar and Justice Liu, wrote very impassioned and long opinions as to why the Supreme Court should hear the case. When we were at the trial court level, when we were trying the case for 3 months, everyone assumed, on both sides, that the case would eventually wind up in the Supreme Court because of the importance involved. But for some reason it didn't.
Yeah. And at what point does a case make it to the Supreme Court of the United States?
Well, this was an interpretation of the California Constitution. So the United States Supreme Court would not get involved in that.
Heard to that. California has a constitution itself, and then the United States too. Can you kind of elaborate on how what the different statutes are in those two?
Sure. When there's a question of interpretation of state law, as long as that state law does not conflict with federal law, because you recall that we have what's called federal preemption, where 2 statutes cover the same area or an interest in federal sphere, there is a preemption by the federal courts. So in that respect, they will get involved, and also with respect to criminal issues, the Bill of Rights, for example, the Fourth Amendment, Fifth Amendment, those various criminal protections that people have, even though they're litigated first in the state courts, they can be sent through the federal system all the way up to the U.S. Supreme Court because it involves a federal constitutional issue. So sometimes you will see a state court upholding a warrantless search of a home and find the United States Supreme Court reversing that based upon the U.S. Constitution.
And what are some of the other cases you've officiated that you think were pretty noteworthy?
Well, there was a very sad case here in Los Angeles. It was widely publicized at the time, where a gentleman had barricaded himself with his very young child, I think 2 or 3-year-old child, in his motor auto repair shop. And he was high on drugs, the evidence showed, and intoxicated. And the mother asked the police to get the child away from him. He had previously threatened another child. He had a gun, he was armed, and there was evidence that there may be other people in that shop with him as well. So the SWAT team was called, and it was a very touchy situation, obviously. And a shooting ensued where there were shots fired in and out of that office. The dad was shooting and the police were shooting in, and he was holding the child at his chest, and unfortunately, very tragically, the child died of a police bullet. And the father died as well, of course, during that process. And there was a lawsuit brought on the issue of the alleged use of unreasonable force by the LAPD, and the case came before me, and I heard the evidence, and I utilized a mechanism in the law which was called a nonsuit. It was a jury trial, a nonsuit where I found that based on the evidence before me, there was insufficient evidence presented by the prosecution to show that under these circumstances, there was unreasonable force used by the police. There was some discussion by the lawyers, obviously, why I didn't let this go to the jury to decide. And the case went up to the Court of Appeal, and the Court of Appeal upheld my decision to dismiss the case on that basis.
Yeah. And when you're hearing one of these cases, which is very emotional, how do you keep your emotions out of it and really just look at the evidence?
Well, that's what we're trained to do, and I can tell you that in some of these cases, particularly in some family law cases, where the issue of child neglect or child abuse comes up, I can sometimes feel tears welling. I mean, that's just a normal human reaction. But we have to make sure that that does not influence our factual finding requirement. However, certainly when you leave the bench, sometimes you have to take a break and calm yourself.
Of course. And in what cases is there a jury heard, or is there just a judge? How is it decided whether there is a jury?
In civil and criminal cases, generally, juries are permitted. But if both sides give up the right to a jury, then it'll be heard by a judge. Family law has no juries whatsoever. Probate has no juries whatsoever. Neither does dependency, juvenile dependency, nor juvenile other juvenile cases. But the decision to give up the right to a jury being made by both sides, then both sides have to really evaluate the judge and make sure that the judge they're in front of then, who's going to make the decision, is fair and that they can live with the result. Sometimes in criminal cases where the facts are really egregious, I mean, if it's an allegation of a brutal child murder or child sexual abuse, where the parties think that the jury would just be inflamed by the graphic nature of the testimony, sometimes juries are waived in those circumstances, and the judge is then, who allegedly has a more dispassionate mind, is let to decide the matter.
And as you hear these cases, did you decide to do family law?
When I first came downtown in 2001, I did ask to do family law. And then I did that for 2.5 years. And then I went to civil for 12 years, during which time these other cases that I talked about came up. And then a couple of years ago, I thought, gee, you know, I think I'd like to do family again. And one judge was going to be absent from his bench. One family law judge was going to be absent for his bench for a few months, and so I took his place just to see if I still liked it, and I found out I did. And so then I asked the supervising judge of family law if they wanted me as a family law judge, and she said sure. And so the following spring, in February of 2016, I joined family law again.
And what is the day-to-day duties you have as a judge?
Well, as a family law judge?
Yes.
Well, we have calendars 3 days a week, Monday, in my case, Monday, Tuesday, and Wednesday, where we hear hearings involving custody, support, property issues, and attorney fee issues. Then on Thursdays and Fridays, we are left with trials. So sometimes our supervising judge will then send a trial or a restraining order hearing to us on a Thursday or Friday, because we have more time to hear them then. And so that kind of rounds out our week.
And then is it a term system for judges? Do you have terms to be a judge?
Our terms are 6 years each. So every 2 years, 1/3 of our judges are eligible to be challenged on the ballot. Now, the reason your viewers will very rarely see judges' names on the ballots, Superior Court judges' names on the ballots, is because relatively few Superior Court judges are challenged for re-election. They're generally re-elected. Those that they do see will often be for open seats where a judge is retired and the governor has not had a chance to fill that seat. So you'll often see candidates for those open seats on the ballot. But that's every 2 years, 1/3 of our judges are up for re-election.
And do you plan to continue being a judge after that?
I do. I am enjoying it very much. I'm thinking that I will keep doing it for as long as my health and my mind holds out, and we'll see what happens.
Yeah. And my final question I really like to ask all my guests is, what do you think is the best advice that you have ever received?
It would be in context of being a judge, and that is to make sure that when you take that bench every day, that you understand what you're doing, that you're affecting people's lives, that you're affecting their futures, and that awesome responsibility has been given you by the people indirectly through the governor or through the electoral process. And you have an obligation to do the best you can. And so I thought that was pretty good advice, and I've tried to follow it.
Yeah, and I believe you have. Judge Treu, thank you so much
My
for
pleasure.
joining me here today.
Thank you, Noah.
And thank you all so much for watching. We will see you next time.